the week, in a webinar, someone asked the question on how can one discipline during these unusual circumstances of COVID-19. We're hoping to answer that question and various other questions relating to that during the course of this webinar. Welcome to Tokiso. My name is Tanya Fenter. I'm the CEO of Tokiso, and we're going to be running through a couple of slides, and then what I'm going to do is indicate that you ask some questions. For those that have not joined us for webinars before, please use the chat line at the bottom of your screen, send through your questions, and we'll sure to get to them at the end of my short presentation. So certainly we look at just a couple of questions that came up over the last few days, speak at the webinar and also speaking to clients is, what do we do in these unusual circumstances if an employee is alleged to have conducted a serious offence, and you cannot delay taking disciplinary action? Even if people have gone home to work from home, or you've put in extenuating measures to combat COVID-19, how do you go about disciplining one? Because certainly we know the principle of justice delayed is justice denied. The second one, and on the converse of that, is certainly the issue of what if the employee lodges a serious grievance, particularly relating to the unusual circumstances we face at the moment. For example, the employer does something that they feel is fundamental to their rights as an employee and need dealt with immediately. And then certainly the other question that's starting to come up in our day-to-day business is, what if an employee conducts misconduct or alleged misconduct whilst currently working at the office, or when they are in quarantine, or when they're working from home? And a couple of examples are there is sexual harassment. I hope everyone knows, certainly that have dealt with me, that the WhatsApping that message that's on the screen, I want to get quarantined with you, may constitute sexual harassment in terms of our sexual harassment code. I trust you're aware about that. Obviously, discrimination cases with people being at home, they may be WhatsApping or sending messages a lot more regularly than normal. And what if an employee sends something which is offensive and could bring the company's name into disrepute? Certainly if it's done through the company's very respective Wi-Fi, or alternatively just on their personal sites. Breach of confidentiality, I suspect that's going to become a big one as employees work from home, and especially employees that work with a lot of confidential information, such as in our company. Certainly one has to put in quite stringent measures to ensure that confidentiality of information is maintained. And then another example one is a big one which we raised on Tuesday is, what if an employee is aware that they tested positive for COVID-19, alternatively have been badly exposed to the virus, for example, their spouse or one of their children have it, or they were with friends that now have tested positive, and they do not inform the employer of this, and then go into the workplace and risk those around them. Certainly those are the kind of serious offences one could potentially see coming through in the workplace, and which employers will feel that it is warranted to take immediate disciplinary action against employees, and they cannot wait, especially with us having no certainty of how long this is going to be. How long is this? Are we going to be off? Certainly schools have been indicated to only be going back after Easter. I think that's the 15th of April. And what then? What happens after that? So certainly one needs to consider and make provision for these new circumstances we're sitting in, being maybe another 2 weeks, but certainly it could also be another 2 months. So certainly it's something one needs to look at. So one just in terms of looking at discipline, I think it's very useful always to go back to Schedule 8. And I always say this in my webinars, it is an excellent guide to what is fair in terms of disciplinary process. And there is the usual, I'm not going to read it, it is on your screen. Just to go back to can you go back to the previous slide? Is that obviously an employee has a right to be notified of the disciplinary action. The employee must be able to have the right to be represented. It should be in a language that they understand, and they should have the outcome communicated with them, preferably in writing. So that we all hope can still happen, and I'm going to show you how Tokiso has done so. I'm sorry, I'm going to go back to the previous slide. I'm not quite finished there. There's in terms of item number 4, which I must admit I've never really I've applied my mind to, but something which perhaps is worth bringing up and emphasizing is that it says in Schedule 8 that in exceptional circumstances, if the employer cannot reasonably be expected to comply with these guidelines, the employer may dispense with pre-dismissal procedures. Now, we are in exceptional times, and I think that if your workplace is such that it can't comply with some of these particular requirements, then potentially under the subsection 4 of this particular clause of the Schedule 8, one would potentially be able to dispense with particular procedural normal procedures. However, if you are able, particularly with technology these days, comply with Schedule 8 and your disciplinary code, one should certainly encourage that at any given time. So I thought that was very useful. And moving on to the next slide is, I also bring this up regularly, is there is a distinction between having a company policy, a collective agreement, or a contract of employment that provides for discipline management. So if it's simply a company policy, we know that a company policy is a guideline. And if there are circumstances that require you to deviate from your policy, you may do so, as long as it's justified. The second thing is a collective agreement and a contract of employment is different. They are effectively contracts, and you are bound by them as contracts. So to deviate from them will be a lot more difficult. Collective agreements most often have exit clauses, and that's something which parties can look at maybe initiating in the current circumstances. But where possible, try to, because of fairness, because you want to be fair to all parties concerned, try and comply as best as possible to whatever a contract of employment or a collective agreement says. But certainly you do have the option of looking at the exit clause within the collective agreement. Contracts of employment generally don't have that, and you will be generally obliged to comply with whatever's in the contract of employment. But usually most companies have company policies, and looking at that clause that I referred to in Schedule 8, it may be justified to deviate from your company policy. I'm going to deal with a case very quickly where that happened. I'm going to the next slide. It was a case between SABC. It's a early 2016 judgment by the late Judge Steenkamp, where Bamawu, in fact, tried to interdict disciplinary proceedings at the SABC. And in fact, what was in the disciplinary code of the SABC was that hearings had to be presided over by 3 chairpersons, evidence had to be led, and there had to be a right to cross-examine those witnesses. Now, SABC had a situation where they had a huge number of cases. It was close to 200 cases that they anticipated, and what transpired is they realized that by holding individual disciplinary inquiries, because they couldn't hold it as one disciplinary inquiry because each case had specific and different sets of facts, what they decided to do was to hear these matters on paper, submit the allegations in writing, allow the employer a right to respond in writing, and then submit it to Tokiso presiding officers to determine those matters. Like I said, Bamawu attempted to interdict these proceedings on the basis that it didn't comply with their disciplinary code. And it was very interesting what the Labour Court concluded. There's a quote there, and it basically said, in this case, it would appear to me that, firstly, the process adopted by the SABC will not lead to grave injustice. The union members will have the opportunity to be heard. Secondly, and this foreshadows the question of an alternative remedy, justice may be attained by other means that that is in the dispute resolution system prescribed by the LRA. In fact, in the case before me, the exceptional circumstances go the other way. Exceptional circumstances have necessitated the corporation to adopt a procedure other than the normal procedure envisaged in the disciplinary code. Those circumstances are the number of employees involved and the operational efficiencies of the organization. So the courts have recognized that deviating from one's disciplinary code may, in exceptional circumstances, be warranted. So that certainly is one of the issues. So let's look at, so in terms of disciplinary hearings, you can dispense with your code in summary, and you can look at alternatives. Now, we know that the CCMA, and I'm going to be now moving on to looking at very quickly at Section 188As, but we know that the CCMA has limited their processes to telephonic conciliations and Section 189 processes that are in the public interest. So CCMA processes have effectively stopped, and understandably so, considering the risk. I know some people, I still speak to some people who are saying, well, it's not that bad. I'm sorry, but this is not a drill. It is completely justified, the extensive steps being put into place by government and respective organizations, and I think it is the correct thing to do where large crowds may come together. So CCMA, bargaining councils largely are following suit, and the courts have severely restricted what processes are being conducted because they often have very large numbers of people. So with that in mind, moving on, Section 188 inquiries by arbitrators is processes that could deal with discipline management as an alternative where employers are concerned and employees and unions are concerned that in the event that disciplinary processes take place and cases are referred on to the CCMA, there's a concern that there may be delay in those processes being conducted into the foreseeable future. One option is to look at Section 188As. So you may be aware of these processes, but if not, very quickly I'm going to touch on what they are. They are effectively final and binding arbitrations that are being conducted in place of a disciplinary hearing or performance or incapacity hearing. In other words, you bring in the arbitration into your workplace and it's final and binding. So there's only one process. It's not a disciplinary process, appeal, and then you go to the CCMA. It's all kind of quarantining, or bad use of word quarantine, but rather concertinaed into one. Tokiso is an accredited private agency in terms of Section 188A and, in terms of Section 127, and therefore is able to conduct these processes in the stead of CCMA and bargaining councils. So where the CCMA is not hearing your 188A or bargaining councils have closed their doors in respective processes, you still can come to Tokiso, but it does require the consent of all parties concerned in order to conduct those processes. Tokiso, when we do receive these processes, very much like that you'd refer to the CCMA and the bargaining councils, we will appoint an accredited commissioner to conduct those processes. We would give parties 7 days notice, and the outcome would be final and binding on the parties. So very much like we can still conduct disciplinary, grievance and other processes, we can also do your Section 188As and get you a final and binding decision quite quickly. So moving on to how do we do these practically, and this is really where the tire hits the tart, so to speak, is how can we continue with processes when the CCMA and bargaining council and courts have severely restricted what they're doing? And the answer is that being a private agency, and also because we don't deal with large groups of people in one room, we tend to hear our cases at the place where the dispute arises, being in the workplace. We can make provision that limits or prevents the spread of the COVID-19 virus. And also, we've got the option of conferencing facilities. So first and foremost, the Tokiso's online booking system provides that you can book online. You can if you're not registered on our system, please go and register. If you are already, please go online and you'll be able to, from the comfort of your couch, or your desk. You may access panelist availability, etc., and book a panelist online. We also have guidelines on our website for COVID-19 in-person processes, where we have made this available widely to the public, but also to our parties and to panelists who are now complying with those guidelines in respect of conducting processes, so that we minimize contact between people, but also we adhere with the requirements put in place, such as physical distancing that is required. So please do look at those guidelines. They are available on our website. And secondly, we have also developed guidelines on conferencing, using conferencing facilities. We do encourage this where possible. It is unnerving, very much like you speaking to me over or engage with me over a webinar. We can certainly also encourage this where possible. The first time you use it, it is unnerving, it's difficult, you feel uncomfortable, but once you've used it once, it is an extremely user-friendly system and it works very, very well. We have got guidelines in respect of the different types of processes, because obviously arbitrations will attract much more stringent requirements, such as swearing in witnesses and ensuring that witnesses are not interfered with while they give evidence over a conferencing facility. Tukisa will take you through those in detail should you want to access them, but they are readily available. So, and also Tukisa has the conferencing facility. So if you are worried about setting those conferencing facilities up, we can do it on your behalf, not a problem. So in summary, Tukisa is here to offer you process support. We cannot advise on substantive issues, as you know, due to our independence. However, we are here, we can advise you on what process to use where for your particular dispute. We've got guidelines on our website, not only for COVID-19 and conferencing, but also for all our process types, including 118As, hearings, mediations, etc. We will be holding webinars on a weekly basis, simply because we want to keep in contact with you, and also as things develop very, very quickly around COVID-19, we want to keep you up to date with what we're doing in respect of our processes. And finally, we will be offering innovative support around COVID-19 specific disputes that start arising. We're already seeing this happen, and we're anticipating even more of this this developing over time. By Monday next week, we will have a special process up to refer such disputes through Tukisa. So please look out for that. So on that note, I'm going to be moving on to questions. I've got a number of questions that are coming up. So please do put up your questions on the chat line and I will try and get to it. The first question is from Samuel. What happens when the employer does not inform his employees that he's been exposed to COVID-19 or is tested positive when employees are infected? Can employees sue the employer? I think we need to be very careful around this, is that employers, in terms of the Occupational Health and Safety Act, have an obligation to provide a safe working environment. That includes, even more so in the current circumstances, to take every reasonable step to ensure that employees are protected from contracting COVID-19. So where employees fall foul of what is reasonable, then yes, an employee could potentially sue an employer. But on the converse, employees also have just as much a responsibility to the employer and to their fellow employees to avoid spreading the virus. So if an employer has taken reasonable steps, but employees, for example, do not comply with the rules and regulations put in place by that employer, and the employer has taken necessary steps to inform employees of what they have to do, it may be more difficult to sue the employer. Also, you have to prove in this country, unlike other jurisdictions, the actual damage done. So simply to say, well, the employer didn't, I got it, and the employer should have done more, you have to look at what was reasonable, whether the employees complied therewith, and finally, what your actual damages are in order to sue the employer. So I trust that answers that question. Number two, the second question is, but I think to some extent telephonic conciliations might disadvantage parties. So that's a comment. Could it disadvantage parties? Why not put all matters on hold? Certainly, I think that's what the CCMA is doing, is where possible, they're putting everything on hold. And I think that is a valid point. Conciliating over conferencing facilities is limiting, because you're unable to build that necessary rapport with parties to get them to move on their respective positions. So I can understand that telephonic conciliations are not always as effective as in-person conciliations, but I do think that we can use it as an alternative where it's necessary to proceed with matters. So where you're able to postpone matters, maybe that is, and the matter lends itself to be postponed, then maybe that is an option. But where not, do look at using these alternatives. Question number 3 is, we've suspended an employee for almost a year and one is charged with sexual harassment. The employer proposes in the hearing that in terms of the policy, these are exceptional circumstances. The hearing cannot be held without a formal sitting through presentation. The employee has opposed the application and that the hearing is already started. The employer has led 80% of the evidence. The chairperson dismissed and postponed the matter without a date. The employer is not accepting that. Which option do the employer have to conclude the matter without being procedurally unfair? I think these are exceptional circumstances, and if it's a serious offence, I think the best way to do it is to look at engaging with conferencing facilities to ensure that you can visually see the respective witnesses. Telephone, the difficulty with hearing evidence over a telephone is that you can't observe the person. So when you are doing a conferencing facility, using a conferencing facility, you want to visually be able to see the witness and not just see their face, but their whole body, because sometimes their disposition or the manner in which they move could lend itself to interpreting what they're saying. So we actually have in our guideline, we actually mention that the full body of the witness needs to be seen. And secondly, we also require that somebody's in the room to ensure that they're not interfered with. So in that case, because of the extenuating circumstances, I think you need to argue or put it to the presiding officer that you seek to continue and you access the conferencing facilities in that respect. I think this idea, because we have no certainty of how long these circumstances are going to continue, and by all accounts, I think we are looking at a couple of months. To expect employers to hold back on discipline for that period of time is unfair towards the employer. And remember that fairness cuts both ways. So moving to question number 4. Can an employer or chairperson postpone a disciplinary hearing because one of the participants is showing flu symptoms which are similar symptoms to those of the COVID-19 virus? Sure. I cannot comment for that particular presiding officer, but certainly I would, if I was in that particular case and they were showing symptoms, one option is not necessarily to postpone, but consider immediately asking that person that if it's a witness or the employee or whoever the party is, to maybe stand down the matter and ask them to maybe present their evidence in another room and conference it into a separate room so that the person is kept in a separate room. As I've indicated before, and I did a webinar recently on this, I don't like postponements and they should be avoided, obviously not at the expense of fairness, but we should try to avoid postponements wherever possible, simply because it postpones the dispensing of justice. It's very stressful for parties, but there's also potentially, especially if you're using an external chair, leading to a lot of costs. So my suggestion is look at creative ways, be creative and innovative, and give those options to the presiding officer. In those circumstances, put the person that's shown the symptoms into a separate room, put in conferencing facilities, or alternatively give them the option to go home and conference that evidence into the hearing where at all possible. Another question is, are employers obligated to do screening at the workplace? Reasons being, most employees do not have access to medical facilities and they might infect other employees due to contact in the public places. Now, this came up in the webinar earlier this week, and my concern about obligating screening is that there is a potential risk, if it's not already in the employee's contracts of employment, which is a contract that allowing you such consent. I think there could be a privacy risk here. There's a risk that you could be breaching privacy. So I understand why employers want to do it, but you need to do it in a kind of a consistent way that can't expose you to claims of discrimination. And employees must be given the option to say no and then be sent home, and then how do you deal with that? But certainly you're not obliged to put screening in place. I would rather put the obligation of employees to disclose in the event that they're ill, or send them home if they're ill. Alternatively, give the employees the right to stay at home if they've got any symptoms of illness whatsoever. So that's one option. What we've done in our workplace, because we also don't want employees to unnecessarily go to doctors because they're being inundated at the moment, is we've dispensed with the requirement of a sick note, unless it's very, very serious. So maybe though you can look at creative ways like that in these current circumstances. So I trust that happens, but no, employers are not obligated to put in screening in place. Our next question, number 6, is, are employers obligated to do, sorry, I've already done that one. Question number 7 is, that I'm going to deal with, is referring to Schedule 8, a qualifying deviation from the pre-dismissal procedure. Would reverting to having a 188 inquiries only via online conferencing open up employer up to procedural challenges? I don't think so. I don't think so at all. It's becoming common practice throughout the world, and our courts have also used conferencing facilities in exceptional circumstances where witnesses are unable to come to court. So no, I don't think it would. Just make sure that you have proper conferencing facilities in place. On our guidelines for conferencing facilities, which are on our website, you'll see that we do require all parties to have good connectivity and good Wi-Fi, reasonable Wi-Fi, to ensure that it's not jittery and it's a good connection. So things like that need to be checked. And where employees don't have it, maybe the employer can make that available. But certainly using on conferencing facilities will not render the process per se unfair. I've got another question here, is our employees have sent a group grievance that they wish the employer to allow all employees to work from home. Maybe, again, I'm going to raise a couple of things. Everyone is stressed at the moment. I always say is that if you look at the shopping, everyone's saying don't panic, but look at the shopping malls, everyone is panicking. There's panic buying, people are anxious, and that does have and different people respond differently to crisis situations. So we need to be sensitive to some people maybe really panicking around this and wanting to work from home. In my view, and how we've dealt with it, is it's a 2-stage process. The first question is, are people able to conduct their functions reasonably in the majority of cases? Well, can they conduct their functions from home? Are they able to? And the answer for a lot of white-collar workers is yes. The second question, when asked that if their functions allow them to work from home, and the answer is yes to that, then do their circumstances at home, are they such that they are able to in fact work from home? So for example, if you're working with a lot of confidential information, an employee would have to show that they can protect confidentiality in the work at home or where they're going to work from. So it's not, or for example, an employee may not have Wi-Fi or they may not have a room that's quiet to work in for them to conduct their work. And I think it's worth taking those things into account. But for employees just to demand that they work from home can't in itself render that you're obliged to do so. Because an employer, as long as you've ensured that you've put all reasonable steps to ensure that you prevent the transmission of the virus, and you've taken into account each individual's particular circumstances, I think that's how I would look at it and ask for every employee, whether they can work from home, whether their job allows it, and number two, is the circumstance at home allow them to work from home. So yeah, interesting question, that one. Another question is, can an employer chairperson postpone a discipline? I think I've answered that one already around flu-like symptoms. Next one is, what advice should be given to companies if they want to give annual leave to employees when some employees do not have enough leave balances? That's extremely difficult. There's a couple of options here. If somebody is showing flu-like symptoms and are ill, then they can use their sick leave. Another option is for employers to look at some form of special leave. Another option is to look at unpaid leave. Alternatively, sorry, that's just clearing my throat. I do apologize. Another option is to look at extending leave, allowing people to go into a kind of a balance where they owe leave. And that's maybe these are circumstances that employers may want to do that. So there are ways of doing it. The other option is to say to negotiate and say to employees, maybe we only pay you a portion of your leave during this period, so you mitigate against the impact of this. But whatever you decide on all these issues, it must be preempted by a process where you consult with employees and engage with them around options. Don't be unilateral. Don't be heavy-handed. Speak to your employees and find a solution between the two of yourselves, where at all possible. Okay, so let's just see, I've got a question number 12. Sorry, I'm actually, they are counting the number of questions coming through this. They're coming in thick and fast. If an employee has to be quarantined for 14 days, will those days be taken from sick leave? And if those need to be further be kept in hospital, where would those be taken from? First and foremost, it's very clear what sick leave is. Sick leave is where you've got where you are ill, where you actually are ill, unable to come to work due to being ill, or you have and that's usually through a certificate from a medical practitioner. So if somebody is actually ill, it's from sick leave. However, somebody is just being quarantined and they show no symptoms of illness, then that is not sick leave. Unless the employer wants it to be, or if you agree with your employee that you use sick leave for that on that basis. But in fact, what could happen then is that employers can send somebody home, and that can be drawn from their annual leave. Alternatively, if the employers are in a position to do so, look at some form of special leave that employees can be given in relation to quarantining processes. So I trust that answers that question. I've got a question here. Where airline companies derive their revenue from ticket sales in light of flight restrictions, can the company implement short-time or layoffs if there's a decline in business? If their collective agreement provides for it, but that is the collective agreement. A collective agreement is agreement between union and the company. For layoff or short time, yes, it can be implemented in terms of that respective collective agreement. Otherwise, there's no provision necessarily in the law that provides for that, and you would need to negotiate that with your respective employees. And it is an option. And rather than having people being retrenched, rather let's try and get through this difficult time through some discussion between employers and employees, finding alternatives to retrenchment, so that when things do turn back to normal, let's hope they do soon, they're able to go back to their everyone's able to go to respective normality and jobs can continue. Another question I've got here is, our care facility received communication from the department that a person who's shown symptoms of COVID-19 and is not permitted to refuse testing or isolation. Who makes the decision that testing is obligatory? I don't think testing can be made obligatory by an employer unless it's in your collective agreement that it is. If somebody's showing symptoms, they must be sent home. An employee that comes to work knowingly that they've been exposed or has it and puts other people at risk can face disciplinary charges, and they can indeed even face criminal charges. But if you've received formal communication from a department indicating a person's been exposed, you've got a responsibility to send them home, in my view. And because you as an employer have an obligation in terms of the OSHA Act, that's the Occupational Health and Safety Act, to ensure that it's a safe work environment, and on that basis you've got a responsibility to act and send that person home. So to what extent are employers obliged to provide a safe and secure environment? They are obliged where reasonably possible, and every workplace is different. So what you do in an office environment will be very different to what you do on a mining environment. So there's no one size fits all approach to what is a safe and secure steps to keep your workplace safe from the COVID virus. So I'm going to take one or two more questions, and then we'll stop at that point. I see they're still coming in thick and furious. Can an employer force an employee to take unpaid leave where there is no leave available? Is there social responsibility on employees to be accommodating? Is there social responsibility? Is there a moral obligation on employees to be accommodating in these difficult times? I think yes. The answer is, in my view, yes. We should try and be kind to each other. That's my kind of mantra at the moment, is be kind to each other. It is difficult for everybody concerned. However, employers also have companies to run and are in very, very difficult situations where they're losing income largely. Some employers have absolutely no income at the moment. So yes, where employers are able to accommodate employees, please do. However, where employers aren't able to, then what's the other options to employers other than unpaid leave? Employers are going to be looking at alternatives such as maybe reduced pay, paying a portion of a salary, alternatively giving leave credit, just extending leave credit and allowing people to go into leave credit. Another option obviously is retrenchment, which is one we so want to avoid where possible. So yes, in my view, there is a moral obligation, but obviously we don't want a situation where companies are unable to function and close their doors. Last question I'm going to take is, can an employer call Tukiso to determine a way forward to video conferencing if there are a number of issues the employer isn't sure how to proceed? Of course, call us. There are a couple of ways to contact Tukiso, obviously through telephone, through email, but we also have a chat line on our website itself. Please make use of that, and we will take you through how a conferencing facility works. Very easy to use, but it's nerve-wracking using technology for the first time, and we will take you through step by step. So we just on a couple of things in respect of our webinars. We will be having another webinar sometime next week where we can answer more questions you have, but please feel free to contact us in respect of any questions you do have with your processes. Call Tukiso with your friends, even if it's to say hello and hear a friendly voice, we're there for you. So certainly I'm going to end it there, and thank you very much for joining us, and we look forward to seeing you at the next webinar. Thank you very much.